Hello, this is Dave Siegel. Welcome to Legal Action, where we talk about different facets of the law. Tonight we're going to talk about divorce and family law, with an emphasis when there are minor children involved. And I'm joined once again by my co-host, Jesse Barrientos. Jesse, welcome to the show.
Thank you. Dave, I feel fantastic. I can't wait to get started. You know, it's just a wonderful, wonderful evening, and
That's going. Great. We're going to talk a little bit about divorce and family law. Can you give a little bit about your background and what you practice in, primarily in DuPage County and Cook County, is that correct? And will?
Yes, and will, and also get out to Kane County. It depends on, the clients that come in, where you go. We do general practice, but always the staple of the practice has always been divorce and criminal law and those things like that. That's just inexplicably intertwined. Been practicing now for about over 14 years and do a lot of divorce as well.
As far as divorce and family law goes, is that an area that you find enjoyment in? Interaction with the clients is a lot more enhanced than in other transactional areas, is that correct?
It is. I always enjoy working with clients, but I will tell you this, that family law, and it covers not just really divorce, it covers so many areas. It covers custody, it covers support, it covers adoption. There are some happy moments in there, but generally when you deal with the family law issues, it's very highly emotional issues that people deal with, and so it's important to be very sympathetic and to be very understanding with respect to your clients and also the parties on the other side as well.
Sure. Can you describe for us the bench and the bar and the participants in DuPage County, for example? What is that like?
What do you mean in terms of the
judges and the practitioners
Sure.
that appear on a daily basis? What can one expect in the divorce court?
Well, I can tell you, certainly in DuPage, we have many seasoned, outstanding judges who've been doing this for many, many years. They're pretty incredible because they have the experience. That's how you learn anything else. I've been before several of them, and I can tell you, when you don't get what you want, you always get excited because you like to get your way in terms of representing your client. But for the most part, the judges are fair. And that's really what's important. It's really a court of equity to make the division between the parties fair and to make it fair for the kids. The attorneys that also practice are also very very good in terms of interact with each other. Their understanding. They're folks that you can trust and working on a professional basis.
Okay. And the judges are conveniently located on the same floor. Is that correct?
Yeah, for the most part. There's a couple odd courtrooms, but yes, it's on the third floor.
But if you find yourself on the third floor at the DuPage County Courthouse at 505 North County Farm Road, there's a good chance you're in a divorce or a family law court. Is that correct?
That's a good chance. Sure is.
Okay. Well, there's many things to talk about when it comes to a divorce and family law case. We spent time on a previous show talking about the grounds, division of property, division of assets, debts, things like that. But there's something that we didn't touch upon. We saved it for a special show because it is that important of a topic, and that is children.
Children are incredibly important. Most of the divorces, most of the complicated divorces have that aspect with the children because there are so many things. We could do probably a year of shows with respect to children and with respect to custody and all that. And again, the most important thing when it comes to children is what's best for them, what's in their best interest. A lot of times, well, most of the time, in divorce actions, each party is trying to jockey for position and to get what they want for themselves, trying to hurt the other party by doing other things, not because necessarily they want something, but they know what buttons to push, they know it's going to irritate the other person. And sometimes they lose sight of their children, the ones that they should be caring most about in the transaction. And kids pick up. They're pretty smart. They know what's going on. Even the little ones, they can sense that. They know when things aren't right, when there's not a chord between the mommy and the daddy. They know, and they can sense that.
Okay. I get a lot of calls throughout the week regarding custody, and it seems that there is a huge misconception on what custody is, how it's awarded, and what it actually means to the person who has custody, to the person who doesn't have custody, and whether or not there's joint custody. Can you describe in some detail the different types of custody that you would find in a case?
Well, we can start with joint custody. And what that means is that, let me back up a little bit. You also have residential or physical custody. The parent who's going to be responsible, who's going to have the child,
Yeah,
the
I think
primary
that's
physical custody of the child.
I think this is where the misconception comes
Right.
in. Somebody feels if the other party has custody or physical custody, that they have the sole decision making. So I think let's take it from the standpoint of decision making first,
Sure.
and then we'll move into physical. So what is joint custody in essence for decision making?
Joint custody gives the non-custodial parent, the parent that doesn't have the child in his possession or her possession all of the time, the ability to make decisions regarding the child's life. That covers many things. That covers the religious upbringing, that covers the kind of day-to-day decisions, what school the child's going to go to, and really joint custody is for parties that can agree, that can come to agreement, because you're going to have a lot of interaction. Regardless of what kind of custody you have, you're going to have interaction with your spouse till your child is well beyond 18 years old.
They can agree on issues as they relate to how to raise the child or children, correct?
That's right. That's
And do you
exactly
often
right.
see that, where they can agree on those issues, but they can't agree on anything else between themselves other than the children?
Well, you can see that sometimes, but if they can agree for the most part on things for the children, then the other things, and that's where they have interaction, it's because of the children, they're going to be more inclined and they're going to be more agreeable on those other issues as well. And that's really the better way to go. Again, harmony promotes good emotional stability for the children as well.
Have you seen an increase over the years in the number of fathers who want to be active in the decision-making in the lives of their children? Have you seen an increase in that?
I really have, and I can tell you, occasionally you get clients, the husband, who wants to take not only a more active role, but who steps up to the plate and who really goes over and above what he's required to do, and that is commendable. I just had one recently that we're working on. Actually, we're going to do our prove-up tomorrow, and it's really someone to be applauded for doing that and to making provisions for his children that are just incredible for school, for health, for retirement, all kinds of wonderful things that most parties are thinking, hey, listen, I don't want to do that. I just want more money in my pocket. So it's an investment in your kids. They're your kids. You have a legal and a moral responsibility to take care of them. And that's what I tell clients too. I tell them, hey, these are your children. You have an obligation to pay support, to support your children. Oh.
Do you think some of the increase is due to some of the institutional advertising that's out there aimed at fathers to have more of an active role, the rights of the father per se?
That may be true, but I will tell you, when you go back, it didn't really used to be. I mean, the father used to get kind of left out. It used to be, okay, well, the mother has most of the rights because she's the one that took care of the children from day to day, and so the father is out working, supporting the family, and really didn't have that as close of a connection. But the laws have kind of changed, and again, it's the best interest of the children. And you know what? Most of the time, the best interest of the children dictates to have interaction with both of his parents or her parents.
So to summarize joint custody for decision-making, that would be where the two parties must agree or talk amongst each other with relating to health, education, religious decisions for the child or minor children. Is that correct?
That's right. Yep.
Okay. Let's juxtapose that with sole custody. And let's just, for example's sake, let's state that the woman, the wife,
Okay.
has sole custody. What would that mean?
Well, that would mean that she makes the day-to-day decisions, that she makes the decision in terms of the child's religious upbringing, the child's school, the general welfare of the child. Essentially, the non-custodial parent, which in this case would be the father, really doesn't have, there's something to say that he's got a right. He doesn't have a legal right, really, to dictate those type of things for the child. And that's what happens in some cases where maybe the father doesn't want to have any involvement with the child.
So in a case where the child has a medical condition that is going to require a surgery, that decision would be completely in the hands of the sole custodial parent, in our example, the wife.
Right, for those kind of decisions, and also just to make sure that everybody knows that even in the case of joint custody, if it's an emergency situation requiring immediate attention, the the parent doesn't have to get permission from the other parent in order to effect that surgery, in order to take care of the child. It's an emergency, they can do it. But if it's something orthodontia or anything like that, in joint custody, they have to consult. With respect to sole custody, the sole custodial parent can take care of that and make those decisions on her own.
As far as procedure goes, let's say a divorce case has commenced. It started. They're in court on the very first date before the judge, and the judge wants to know right off the bat, is there going to be an agreement with regard to custody? Is that correct?
That's going to dictate the course of the case. It really is. There are many reasons to be up before the court for the first time. They give an automatic status date, and it could be on the status date. It could be on somebody's motion for temporary support. I think we talked a little bit about that the last show, for temporary child support or other kind of relief that you're before the court. But if the judge knows that custody isn't really going to be contested, that makes a big difference, because when there's an issue with custody, many other factors come into play. For example, many times a guardian ad litem, an attorney for the kids, are appointed. Very often there's a psychological...
You mentioned guardian. Let's go back a little bit, because some of these terms are well known in the divorce community, but not among laymen. A guardian ad litem, that just doesn't even make a lot of sense.
It's essentially, you have the husband and the wife. The husband has his attorney. The wife has her attorney. They're looking out for their interests. And so the court wants to make sure that the child has an advocate to determine or to fight for what's in that child's best interest. The other thing that comes into play is there may be the psychological evaluation for the parties. They'll go to a psychologist. He'll run his battery of questions and those kind of things. They'll interview people that have interaction. Sometimes it's really up to the psychologist how they see fit to conduct their examination, and that is, they'll come up with a recommendation.
How involved in the case is the guardian ad litem? How is the guardian compensated? And when do they appear before the court, typically? Well,
when the guardian is appointed, he or she will enter their appearance on behalf of the child, and they're like a party. They get notice of everything that's going on. They're involved in every aspect of the case, because again, they're advocating what's in the best interest for their client, which is the minor child.
Okay. What about mediation? Court-ordered mediation with regard to custody.
Mediation, it's always preferable to try to settle something, because when you settle it, you have that sense, hey, I've had some input in this, you've had some input in this, I'm not going to get my way completely, you're not going to get your way completely. So, but the difference is, if you don't, and you let the judge make your decision, then you're going to get a decision, it's going to be removed from your hands, and it's going to be whatever the judge says it is. Now understand, the judge is going to look at all the factors that we talked about before, the judge's experience, but you don't know your situation, nobody knows your situation like you. Okay, so it's very important. Anytime you have an opportunity to resolve something, it's better for everyone involved. Not only that, it's going to cut your expenses, your legal expenses and fees, way down, because that's going to take away litigating all of those other issues that you can't agree on.
I receive a lot of questions concerning joint custody physically, where the parties will actually split where the child lives on a day-to-day basis. 3 days here, 3 days
Sure.
there, back and forth, that kind of thing. Do the courts recognize this as being a good practice or in the best interest of the children?
Well, it really depends on the specific circumstances of the case. I've been involved in some cases where, in fact, that's a similar arrangement. Although it wasn't 3 days here and 3 days here, it was pretty much for the kind of school year. One parent had the minor children, and the other parent had visitation. During the summer, the other parent had the physical custody of the children, and then the other parent had visitation. And so it kind of goes back and forth. There are many ways that can be worked, but again, it really depends upon the specific circumstances, and again, depends upon what's in the best interest of the children.
Well, let's say both parties work a day job. Both parties want to be the physical custodial parent. They don't agree on that. They go to court-ordered mediation. They still don't reach an agreement on that. What kind of standard does the court look to in rendering a decision on who should be the physical custodial parent?
Well, they're going to look at many factors. I mean, it depends on what the particular children enjoyed during the course of the marriage. All right, they're going to look at that as a kind of a factor. They're going to look at what the each individual parent, what his or her motives may be in terms of, why do you want custody and you don't want the other person to have custody of the children. And again, that also depends on what the specific circumstances in that situation are. Just one person is working the other person. You need to look. If one person has maybe some violence in their past, maybe there was an order of protection that was entered, that's going to be a consideration for the courts as well. There are many factors.
But in general, they look at the best interest of the child and determining where to place that child, with which party.
That's right. That's exactly right.
Okay. And the guardian ad litem is going to speak up and make a recommendation, or give an opinion rather, to the court on behalf of that minor child, because the guardian ad litem has reviewed the whole situation as well, correct?
Right.
Okay.
And it's going to be it's something that the court is going to take under advisement, in making the determination of where custody is going to go.
Okay. Whoever has physical custody of the child, the other party has visitation rights, correct?
Yes, generally that's the case.
So in the case of a spouse, let's say the husband who doesn't have the physical day-to-day custody, that individual is going to be afforded extreme or liberal, what do you want to call it? What kind of visitation do you think they'll be entitled to?
Liberal and reasonable visitation. Again, the whole idea, it is within the best interest of the children to have interaction with both of their parents. And the party that doesn't have the custody of the child is going to get that visitation. Generally what happens, just kind of a standard boilerplate deal for visitation, is every other weekend. Say maybe from, I don't know, from 5 o'clock on Friday to 7 or 8 o'clock on Sunday. And then they also determine, usually one person is the one that brings the child, and the other person returns the child. They kind of split it up that way. I mean, it can go many different ways, but that's generally how those kinds of things go.
So overnight visitation for the whole weekend is not unusual?
It's not unusual. What's also not unusual, too, is sometimes there's a visitation period set one day during the week.
An evening, perhaps?
An evening, or it could even be overnight, where one the non-custodial parent would keep the child and then bring him or her to school, or it could just be for an evening. That's not uncommon either.
Yeah.
And then you develop, or you break up the holidays as well. What you have too is, well, we have a lot of holidays, and the best way to do it generally is alternating holidays.
Right.
So
that seems fair, so that one party doesn't always get Christmas Eve.
Right.
One party doesn't always get Thanksgiving Day. I mean, it fluctuates back and forth, odd even, correct?
Odd even, exactly. And then sometimes, parties are pretty good about doing that, okay? And they realize that the child wants to go and open presents at Daddy's house or at Mommy's house, and then they're not going to deny the child that. I mean, again, that's certainly not the rule. That may be the exception, but for the most part, if people can just look at it and say, hey, listen, these are our kids, you can put our feelings, how we feel about each other aside, and deal on raising your children, wow, what a difference it would make. What a wonderful error that would have.
Right. It just seems like we're talking, though, about the child being with one party during the week, one party alternating weekends. To me, there seems to be an emptiness there where the child really isn't living with both parents, and it can never be 100% right, to me. Do you agree?
It really, I agree, it's different. In fact, in DuPage, they have kids care and coping, which is a class, and you're aware of that too.
Let's talk about that. What is that class exactly?
It's a class for the parents. The parents have to go and have to secure a certificate before they can get a divorce that basically kind of teaches them exactly the things that you're saying. People are sometimes oblivious to the fact that the child is going to be impacted by the separation. And so it gives them information on how to deal with that and how to go about the process and deal with the child. It's a very great program, and it's worthwhile.
Right. Well, a lot of parties can't separate the divorce issue between themselves and the best interest of the child.
Yeah.
So I think the class kind of teaches them to not make derogatory statements about
Right.
each other in front of the child. In other words, try and soften the injury that the divorce is going to cause upon their child. Correct?
That's right. And in many instances, again, some more boilerplate for the marriage settlement agreement or judgments, really, have language in there that indicate that you're not supposed to make any disparaging remarks or comments about the other. You're really only supposed to promote and foster the love and respect for each parent in front of the children.
What can happen in the summer and Christmas? Is there such thing as extended visitation, or?
In the summer, generally, whatever the summer break is, it might be 8 weeks or 4 weeks or 3 weeks, depending upon how each party agrees. It can be continuous and uninterrupted, or it can be broken up. Generally, there's a notice provision that by a certain month, the non-custodial parent has to give notice to the custodial parent to let them know that he wants to exercise or she wants to exercise visitation for this period of time. And they're able to take it. But while the child is in the care or for the extended visitation, the custodial parent also has rights to have telephone contact. They have a right to know where the child is. That's sort of like an itinerary of where you're going. And it also happens, too, for shorter vacations if you're going outside of the state or if you're going outside of the continental United States as well.
Okay, let's talk about that. On extended visitations, for example, in the summer, let's say father wants to take the child to visit grandma in Texas or
Sure.
Disneyland or something like that. What is the procedure for doing that? Can he just go?
If grandma wants to take him,
No, they want to go visit grandma.
they want to go visit grandma and go.
They want to leave the state.
Right. Well, if it's during his time that he has a child, and it's in the decree, and generally it is, to give notice to the other party that that's where you're doing, and to give a complete itinerary. In other words, we're leaving on this date, on this airline, and we're going to arrive in Florida, in Orlando, at this time, and we're going to be staying at the Wyndham, and we're going to be from there maybe going to Disney World or wherever, but just an itinerary so the other non-custodial parent knows exactly where the child is, and also to provide contact numbers. And these days with cell phones, contacting is very, it's easy, but only if the other person answers the telephone.
Okay. Not every case is so agreeable where the non-custodial parent is going to get an extended period of time in the summer and be able to travel all around the world. Unfortunately, there's cases where one of the spouses is not trusted alone with the child, whether it be for violent reasons or chemical dependency problems. What is the remedy? What is supervised visitation?
Well, supervised visitation, it's exactly that. It's allowing someone to exercise visitation with his or her kids under the guidance of a supervisor.
Who could be a supervisor in that case?
There could be many instances. The county has places that specifically supervise visitation. It can be a family member. It could be grandma and grandpa. It could be an aunt and uncle. It could be a family friend. There are many ways to kind of work that. But again, the main focus is the best interest of the kids. And so you have a situation where, hey, nothing can happen because there's somebody watching and making sure that is going to protect the kids, that nothing funny is going to go on.
Now, if you have a visitation schedule as part of an order or a decree,
right,
and it says, father is going to pick up the children Friday evening at 6 every other weekend, and he is derelict in that responsibility, what can what can the custodial parent do? Can the wife deny visitation?
You can't deny visitation. And you can't make someone exercise visitation. If it says in the decree that you have visitation from this time to this time, and he or she doesn't show, you really can't enforce it. You can't make somebody exercise visitation. Now, that's not good for the child on many, many levels. Again, that's
right.
fodder for years of shows. But you can't make somebody exercise visitation. However, occasionally somebody might not be able to make the visitation, have a legitimate reason. Maybe you got stuck for work in a different state and unable to fly back. Many of these things have provisions. Many of the decrees have provisions for you to give notice, generally a couple days before, certainly as soon as you're aware that you're not going to be able to exercise that visitation. And also some of those decrees have the ability for you to have make-up visitation as well.
What if somebody appears for visitation to pick up the children and they appear to be intoxicated or high or something?
Well, then, in a situation like that, and again, I want people at home to understand, each case is specific, and you should go and contact a competent divorce attorney, a family law attorney, before you take any action with respect to that. But in a case like that, you don't have to relinquish the children for visitation.
Especially if you feel there's a harm that could...
If you feel there's a harm. There may be some consequences, but either way you look at it, what is more important? The consequences that I may face, or the safety of my children? I think the safety of my children is going to be paramount there. And again, in order to document or prove these things, that's another matter. Yeah. But again, the safety is what's important.
I would take my chances in front of the judge, that the judge would understand that in the best interest of the children, I didn't want to let them go.
I would too, and the very next thing, if that continued to happen, would be probably a petition to do some of that supervised visitation.
Or deny it outright, no?
Exactly.
Okay. What other issues concerning visitation do you think are important when it comes to the minor children?
Well, visitation, it's really, really important to be timely. It's really important for the parents to do what they say to their children. A lot of times that's what you see. Oh, Daddy promised this or Mommy promised that. And you know what? They're so very precious and so very important. It's so important for you to follow through. Right. It's an investment in your kids. Do what you say you're going to do when you say you're going to do it.
In your experience, have you seen cases where the non-custodial parent who wanted custody but wound up not gaining it, have you seen that individual be happy with extended visitation?
Well, any time with your kids is fantastic, but we're kind of selfish people generally. If we don't get what we want when we want it, we're not very happy. And we talked about mediation a little bit earlier. And in mediation, when you compromise, neither party gets everything that they want. So neither party is going to be quite happy with what they get.
Correct. Yeah, there's so much to talk about. We've covered the basics of custody, whether it be sole or joint,
sure,
decision-making and physical. We talked about visitation, liberal, alternating holidays, alternating weekend, that kind of thing. I think we just tipped on the important topics, and we're going to dive in deeper at a later show.
Yeah, that sounds a very good, Dave. But I think what would be, if you wanted the folks at home, just to set them with just one important thought, what would that be?
Work it out.
That's right.
Work it out if you can, if it's all possible. Thank you very much, Jesse, for joining me today.
You're welcome.
This has been Legal Action. I'm Dave Siegel. We'll see you next time. Thank you.